Right, we're on Unit 1, Module 8. So this is where we're talking about keeping records. Why is accurate record keeping important? To comply with legislation, to provide a clear audit trail of the incident or accident. So an audit trail is basically a paper trail to show a timeline of evidence. Okay, an example could be checking historic bank statements, um, stuff like that, or a statement that you've written previously and it corresponds with any other evidence like visual, okay? And also to prevent yourself from having to rely on your memory. This is because with a civil or criminal case, it could take a year or two for the judge to call up the case, by which you would have by which time you would have forgot some of that detail. So this is why it's important to write everything down in a statement. Even if you get the person that you're dealing with is swearing at you, we don't just write the subject, give their description was being abusive towards me. You need to actually write down the actual words they used. A lot of people think that because it's an official document, you can't swear on it. Obviously you can, because the judge needs to be able to see what you went through. So if someone's swearing at you, you need to write down the exact words that they used, because it paints the picture of what you went through. Okay, typical records you may complete include incident reports, accident records, searches and checks, logbooks, normally called daily occurrence books, they are. Your pocket notebooks if your security company issue them. Some of the decent security companies still do. Search, visitor and key registers, duty sheets, lost and found property registers, message books and handover reports, any other site-specific reports. So with your communication and documentation, both have to be ABC, accurate, brief, clear. Your notebooks are still official documents, must be used properly at all times. So you shouldn't be writing people's phone numbers in it unless it's a witness for an incident that you're dealing with. Only be used to record work-related matters, for making accurate, timely notes while working at a scene. So if you see a vehicle circling your site several times, then it's going to be worth making a note of the vehicle make, registration, a description of the people inside if you can see that, and obviously the time and date and how many times they've been circling your site. Okay. Ensure that sufficient details about a routine or unusual event are taken at the time, and a fuller report can be made of the incident later. Must be kept securely, as may contain confidential information. So you shouldn't be going to and from work with your pocket notebook. You should have a locker at work somewhere for stuff like that, because you might have witnesses' personal details on there, and you don't want to lose that book with that type of information in, do you? Okay, no erasers, so no rubbing things out or using Tipp-Ex, no leaves or pages torn out, no blank spaces, no overwriting, no writing between the lines, and keep your statements in direct speech. Where it says no writing between the lines, that can literally mean no writing between the lines, because we get people who do try and squeeze words in that they forgot to put in. You can't do that on an evidence statement. If that won't be tendered or acceptable as evidence if you're making a mess of your statement. Another way I interpret it is not only that, no writing between the lines could be similar as no reading between the lines. So my interpretation is only keep what you know to be truthful and factual in your statement. Don't put your opinion in there. If someone you might think looks like a drugs dependent, a drugs addict, you can't put that in there because we're not qualified to say that. Even though we might know what they look like, you still could be wrong It could be a person with a medical condition who just looks that way or talks that way, and they might not be on any drugs. So bear in mind, you don't put your own opinion of someone in a statement, just pure facts. Incident reports will need to show who the report is for and who it's written by, what happened, action was taken, what was the result, and when, the day, time and date, and where, place of incident, details of any other witnesses, people, injuries or property, and records need to be completed as soon as you're able to following the incident and should be purely factual that it is, without personal opinion, and each separate report should be signed, dated and timed. If you've got a witness, please get them to sign your statements as well. Because if you go to different companies a few months or years later, and then the case gets called up, the court, Crown Court, magistrate or judge may only be able to call you up or summons you to attend court because your colleague hasn't put their signature to it. So please make sure your colleague, if they are a witness, they sign it as well, or write their own, even better. Okay, statements is a written account of what evidence a witness can give about an incident, and the rules about statement writing and giving evidence can be found in the Police and Criminal Evidence Act, or PACE 1984. Statements are taken for the following reasons: to allow police officers to collate and evaluate evidence during investigations, to record witnesses' evidence as soon as possible after an incident, and to submit as evidence when not contested in court to save the attendance of a witness, and to refresh a witness's memory prior to actually giving verbal evidence in court. Like I said before, you might forget something that's a year or 2 years later, which is why you need an evidence statement so you can read back on. If force is used against a person or while carrying out a lawful arrest, the incident will need to be explained in detail, including time, date and location of the incident, how the security operative was called to the incident, which was you, what type of incident it was, if the SO was alone, how the incident was approached, what was seen and heard, number of people involved, and the state of mind of people involved. You might think you're not qualified to assess that, but we all know if someone's in an emotional state, don't we? So that's what it's referring to more than anything there. And what I will say is, if you ever do have to go to court, bear in mind the defence solicitor of the subject that you may have arrested, they will talk to you nicely, but what they're likely going to be doing is trying to catch you out or make you slip up or try and make you look like you're incompetent. I'll give you an example. When it comes to the scone procedure, you've got to follow the steps of a scone before you arrest a shoplifter, okay? So you need to see a member of the public in your store approach an item, so that's A. S is for select an item, so they've selected an item off a shelf or freezer or wherever it may be. C is for conceal. You've actually witnessed them conceal the item in a bag, in the pocket, under a pram, anywhere. O is for observation, so you have to observe that customer 100% of the time with no gaps whatsoever. N means they've gone past the last till, the last point of payment, they've made no attempt to pay, and then E is for exit. As they're about to exit your store, that's when you can arrest them for theft. You followed all those points, the full procedure. In a previous case where a guard arrested a shoplifter, the shoplifter challenged it, went to court, and that person's defence solicitor asked the guard, did you follow the full procedure? It was called scone back then, they've added an A on the beginning now, a scone. And he said, yeah, followed it all fully. The solicitor asked him, what time did the incident occur? For example, let's say he said 2:20 in the afternoon. How do you know what time it was? The solicitor asked. I looked at my watch. Those 2 seconds of looking at his watch destroyed the case because that that suggested he didn't have his eyes on that person 100% of the time. So if you remember, O in the Ascombe procedure is observation. You've got to observe them 100% of the time without any gaps. And that's what the solicitor was after, to make the guard look stupid. And that the case got thrown out just for those 2 seconds, believe it or not. So be careful. A solicitor will always try and make you look stupid. Even though they come across like they're being nice and friendly, they're not. Okay? The use of force in statements, okay? The offender's size in comparison to yourself as the SO, how the SO felt about the situation, actions that were taken, what was said to the offender, what was said to the SO, why the SO decided to use force, how much force was used, what level of resistance there was, how the offender was restrained or ejected, how they were held until the police arrived, and whether there were any injuries. Details of the officer who took the offender from the SO, so the collar number of the police if you can get it. Try and get a crime reference number as well. For your client, they'll be made up with that for insurance reasons. Details of any witnesses, details of first aid or medical support if provided, and details of support involved or any follow-up action that's required. Descriptions of people may need to be given when providing a statement, and accurate information must be provided. How long was the person observed for? 100% hopefully. How far was the person from the SO? What were the lighting conditions like? Was your view impeded at any point? Has the SO seen the person before? If so, how many times? Or is there any special reason for remembering this person? Covering all these points will provide good evidence for the prosecution. So when you're attending court, you'll follow your organisation's policies and procedures. You'll arrive at court in good time and let the CPS know you're there. People have asked me in the past what the CPS, that's the Crown Prosecution Service. You'll read through your statement if not already read through. Follow any legal advice from your representative if your company have one. Avoid giving your opinion unless asked, and keep your answers straightforward. Try and just give yes or no answers if you can, because remember, their defence solicitor is trying to catch you out or make you slip up or make you look incompetent. Try and give them very little as possible. And what I would say is, even though a defence solicitor may be asking you questions, as it says there, you will be asked questions by the solicitors or barristers. You're going to be looking at the judge, jury, or the magistrate if it's a civil matter, because that's who you need to show respect to. So even though their solicitor might be asking you questions, you don't need to look at them. You don't need to show them any respect because they're trying to make you look silly. Okay, so address your answers to the judge, magistrate, or jury. If you don't know the answer to the question, then say so, and always follow your assignment instructions. Okay, so explain the importance of accurate record keeping. What did we just say? What have we just gone through? If you need to look back, go back and play, and then make a note of the answer. Identify the types of information that should be included in your records. And describe the process of attending court to give evidence. We just covered that then. Okay.